Bar question and answer in Remedial Law 2018. 2018 Remedial Law Bar Question Number 1. Danielle, a Filipino citizen and a permanent resident of Milan, Italy, filed with the Regional Trial Court of Davao City, where she owns a rest house, a complaint for ejectment against Dan, a resident of Barangay Daliao, Davao City. Danielle's property, which is located in Digas City, Davao del Sur, has an assessed value of 25,000 pesos. Appended to the complaint was Danielle's certification on non-forum shopping, executed in Davao City, duly notarized by Attorney Dane Danosa, a notary public. Was there a need to, letter A, refer the case to the Lupong Tagapamayapa or for prior barangay conciliation before the court can take cognizance of the case? Suggested answer to letter A, no, there was no need to refer the case to the Lupong Tagapamayapa or for prior barangay conciliation, because under the Local Government Code, the requirement of prior barangay conciliation only applies if both the parties reside in the same city or municipality. Here, the plaintiff Danielle resides in Milan, Italy, while defendant Dan resides in Davao City. Hence, the requirement of prior barangay conciliation does not apply, and thus there was no need of prior referral to the barangay. Bar question letter B. Was the action properly instituted before the RTC of Davao City? Suggested answer to letter B. No, the action was not properly instituted before the RTC of Davao City, because under BP bilang 129, it is the Municipal Trial Court which has exclusive original jurisdiction over actions for ejectment cases. Hence, the RTC has no jurisdiction over the action, and thus the action was not properly instituted before it. Bar question letter C. Should the complaint be verified or is the certification sufficient? Suggested answer to letter C. The complaint should be verified, because under the rules of civil procedure, a complaint for ejectment cases must be verified. Here, the complaint contained a certification against forum shopping, but this is not the same as verification, in which the affiant states that he has read the complaint and that the allegations therein are true and correct of his personal knowledge or based on authentic Bar records. Question number 2. Then Denise Incorporated and David, both stockholders owning collectively 25% of Darwinkle Incorporated, filed an action before the RTC of Makati to compel its board of directors to hold the annual stockholders meeting on June 21, 2017 as required by Darwinkle Incorporated bylaws, with prayer for preliminary mandatory injunction to use as record date April 30, 2017. The complaint alleged, among others, that the refusal to call the annual stockholder meeting on June 21, 2017 was rooted in the plan of the board of directors to allow DataBank Incorporated, which would have owned 50% of Darwinkles Incorporated after July 15, 2017, to participate in the annual stockholder meeting to effectively dilute the complainant's shareholdings and ease them out of the board of directors. Then Denise Incorporated and David paid the amount of 7,565 pesos as filing fees based on the assessment of the clerk of court. The board of directors filed a motion to dismiss on the ground of lack of jurisdiction. They averred that the filing fees should have been based on the actual value of the shares of the then Denise Incorporated and David, which were collectively worth 450 million pesos. If you were the judge, will you grant the motion to dismiss? Suggested answer: no, if I were the judge, I will not grant the motion to dismiss. In a case involving similar facts, the Supreme Court held that an action to compel the corporation to hold the annual stockholders meeting is one which is incapable of pecuniary estimation, since the purpose is not to recover property or shares, but to compel holding of a meeting. Hence, the docket fee should not be based on the value of the shares of the corporation. Bar question number 3. On February 3, 2018, Danny De Lucio, Sheriff of the RTC of Makati, served the order granting the ex parte application for preliminary attachment of Dingoy against Dudong. The order, together with the writ, was duly received by Dudong, On March 1, 2018, the sheriff served upon Dudong the complaint and summons in connection with the same case. The counsel of Dudong filed a motion to dissolve the writ. Question letter A. Can the preliminary attachment issued by the court in favor of Dinggoy be dissolved? What grounds can Dudong counsel invoke? Suggested answer to letter A, yes, the preliminary attachment issued by the court in favor of Dinggoy may be dissolved, because under the rules of civil procedure, no levy on attachment pursuant to the writ of attachment shall be enforced unless it is preceded or simultaneously accompanied by service of summons, together with the complaint and other accompanying documents. This is the ground that Dudong's counsel may invoke. Here, the summons and complaint were served not before or during the levy on attachment, but after. The attachment was thus improperly enforced and may thus be dissolved or discharged. It should be noted that in case of irregular enforcement, what will be dissolved or discharged is not the writ of attachment, but the attachment itself. The writ remains to be valid. Bar question number 4. Dick Dixon had sons with different women. Dexter with longtime partner Delia, and Dong Dong and Ding Dong with his housemaid Divina. When Dick fell ill in 2014, he entrusted all his property titles and shares of stock in various companies to Delia, who in turn handed them to Dexter for safekeeping. After the death of Dick, Dexter induced Dong Dong and Ding Dong to sign an agreement and waiver of their right to Dick's estate in consideration of 45 million pesos. As Dexter reneged on his promise to pay, Dong Dong and Ding Dong filed a complaint with the RTC of Manila for annulment of the agreement and waiver. The summons and complaint were received by Dahlia and housemaid of Dexter on the day it was served. Dexter filed a motion to dismiss on the ground of lack of jurisdiction over his person. RTC Manila granted the motion to dismiss. Dong Dong and Ding Dong thereafter filed a new complaint against Dexter for annulment of the agreement and waiver. Before Dexter could file his answer, Dong Dong and Ding Dong filed a motion to withdraw their complaint, praying that it be dismissed without prejudice. An order was issued granting the motion to withdraw without prejudice on the basis that the summons had not yet been served on Dexter. Dexter filed a motion for reconsideration of the order of dismissal. He argued that the dismissal should have been with prejudice under the two-dismissal rule of Rule 17, Section 1 of the Rules of Court in view of the previous dismissal of the first case. Will the two-dismissal rule apply, making the second dismissal with prejudice? Suggested answer, no. The two-dismissal rule will not apply, making the second dismissal with prejudice. The Supreme Court has held that in order for the two-dismissal rule to apply, both dismissal must be at the instance of the plaintiff. Here, the first dismissal was at the instance not of the plaintiff but of the defendant Dexter, who had filed a motion to dismiss, which was granted. Hence, the two-dismissal rule does not apply and the second dismissal was thus without prejudice. Bar question number 5. Dorton Incorporated or Dorton sued Debra Commodities Incorporated or Debra, Daniel and Debbie in the RTC of Manila for recovery of sum of money. The complaint alleged that on October 14, 2017, Debra obtained a loan from Dorton in the amount of 10 million with interest of 9% per annum. The loan was evidenced by a promissory note payable on demand signed by Daniel and Debbie, the principal stockholders of Debra, who also executed a surety agreement binding themselves as sureties. Copies of both the promissory note and the surety agreement were attached to the complaint. Dorton further alleged that it made a final demand on March 1, 2018 for Debra and the sureties to pay, but the demand was not heeded. Debra, Daniel, and Debbie filed their answer and raised the affirmative defense that while the promissory note and the surety agreement appeared to exist, Daniel and Debbie were uncertain whether the signature on the documents were theirs. The promissory note and the surety agreement were pre-marked during pre-trial, identified but not authenticated during trial, and formally offered. Can the RTC of Manila consider the promissory note and the surety agreement in rendering its decision? Suggested answer: yes, the RTC can consider the promissory note and the surety agreement in rendering its decision. Under the rules of civil procedure, the adverse party who fails to specifically deny under oath an actionable document is deemed to have admitted its authenticity and due execution. Here, Deborah, Daniel, and Debbie failed to specifically deny under oath the promissory note and the surety agreement, which are actionable documents, since Dorton's action for recovery of sum of money is based upon them. Daniel's and Debbie's allegation that they are uncertain as to whether signatures on the documents are theirs is not a specific denial. Hence, the defendants are deemed to have admitted the authenticity of the promissory note and the surety agreement, and the RTC may consider them even if they were not authenticated. Bar question number 6. Darabel Incorporated or Darabel filed a complaint for sum of money and damages against spouses Dake and Donna Dimapelis for unpaid purchases of construction materials in the sum of 250,000 pesos. In their answer, spouses Dimapelis admitted the purchases from Daribel but alleged that they could not remember the exact amount since no copies of the documents were attached to the complaint. They nevertheless claimed that they made previous payments in the amounts of 110,000 pesos and 20,000 pesos, and that they were willing to pay the balance of their indebtedness after account verification. In a written manifestation, spouses Dimapelis states that in order to buy peace, they were willing to pay the sum of 250,000 pesos but without interest and costs. Subsequently, Daribel filed a motion for partial judgment. Thereafter, Daribel filed an amendment complaint alleging that the total purchases of construction materials were 280,000 pesos and only 20,000 pesos had been paid. Darabel also served upon the spouses Dimapelis a request for admission asking them to admit to the genuineness of the statement of accounts, delivery receipts and invoices, as well as to the value of the principal obligation and the amount paid as stated in the amendment complaint. Darabel thereafter amended the complaint anew. The amendment modified the period covered and confirmed the partial payment of 110,000 pesos, but alleged that this payment was applied to spouses of other existing obligations. Darabel, however, reiterated that the principal amount remained unchanged. Question letter A. Is the request for admission deemed abandoned or withdrawn by the filing of the Second Amendment complaint? Suggested answer: no. The request for admission is not deemed abandoned or withdrawn by the filing of the Second Amendment complaint. In a case involving similar facts, the Supreme Court held that the effect of an amendment is merely to supersede the original complaint but not the request for admission. Question letter B. Can the amendment of the complaint be allowed if it substantially alters the cause of action? Suggested answer: yes. The amendment of the complaint may be allowed even if it substantially alters the cause of action. Under the rules of civil procedure, an amendment may be allowed even if it substantially alters the cause of action, provided leave of court is obtained and the amendment is not with intent to delay. Question letter C. Can the facts subject of an answered request for admission be the basis of summary judgment? Suggested answer: yes, the fact subject of an answered request for admission may be the basis of a summary judgment. Under the rules of civil procedure, a party seeking to recover upon a claim may move for a summary judgment based on admission. Section 1, Rule 35 of Rules of Court. A party who does not reply to a request for admission is deemed to have admitted the facts subject thereof. Section 2, Rule 26 of Rules of Court. Bar number 7. Dory Enterprises Incorporated or Dory leased to Digna Corporation or Digna a parcel of land located in Diliman, Quezon City. During the term of the lease, Digna was informed by DBS Banking Corporation or DBS that it has acquired the leased property from the former owner Dory and required Digna to pay the rentals directly to it. Digna promptly informed Dory of DBS' claim of ownership. In response, Dory insisted on its right to collect rent on the leased property. Due to conflicting claims of Dory and DBS over the rental payments, Digna filed a complaint for interpleader in the RTC of Manila. Digna prayed that it be allowed to consign in court the succeeding monthly rentals and that Dory and DBS be required to litigate their conflicting claims. It latter appeared that an action for nullification of a dacion in pagyo was filed by Dory against DBS in the RTC of Quezon City. In said case, Dory raises the issue as to which of the two corporations had a better right to the rental payments. Dory argued that to avoid conflicting decisions, the interpleader case must be dismissed. Does the action for nullification of dacion and pago bar the filing of the interpleader case? Suggested answer: no, the action for nullification of dacion and pago does not bar the filing of the interpleader case. Under the law on civil procedure, in order for lis pendens to bar the filing of another case, there must be identity of parties between the first and the second actions. Here, there was no identity of the parties since Digna was not a party to the action for nullification of dacion and pago. Hence, there was no lis pendens and the filing of the interpleader case was not barred. Bar question number 8. Spouses Dondon and Donna Dumdum owned a residential lot in Dapitan City. Doy Dugan bought said lot and took possession thereof with the promise to pay the purchase price of 2 million within a period of 6 months. After receiving only 500,000 pesos, spouses Dumdum executed the deed of absolute deed and transferred the title to Dory Dugan. The balance was not paid at all. Spouses Dumdum, through counsel, sent a demand letter to Doy Dugan for him to pay the balance of 1.5 million plus interest of 150,000. Doy Dugan responded in a letter by saying that while the remaining balance is admitted, the interest charge is excessive. There being no payment, spouses Dumdum filed with the RTC of Dapitan City a complaint of reconveyance with damages against Doy Dugan. In his answer, Doy Dugan raised, by way of affirmative defense, that the purchase price had been fully paid, and for this reason the complaint should have been dismissed. Spouses Dumdum then filed a motion for judgment of the pleadings, which was granted by the RTC of Dapitan City. The court awarded 1.5 million actual damages representing the balance of the purchase price, 200,000 pesos as moral damages, 200,000 pesos as exemplary damages, 90,000 pesos as interest, 50,000 pesos as attorney's fees, and 5,000 pesos as cost of suit. Was it proper for the RTC of the Dapitan City to grant the motion for judgment on the pleadings? Suggested answer: no, it was not proper for the RTC to grant the motion for judgment on the pleadings, because under the rules of civil procedure, a judgment on the pleadings is not proper if the answer tenders an issue. Here, the answer of Doy Dugan tendered an issue, that is full payment. Hence, the grant of the motion for judgment on the pleadings was not proper. Bar question number 9. In 2015, Dempsey purchased from Daria a parcel of land located in Dumaguete, Negros Oriental. The latter executed a deed of absolute sale and handed to Dempsey the owner's duplicate copy of TCT number 777, covering the property. Since he was working in Manila and still had to raise funds to cover taxes, registration, and transfer costs, Dempsey kept the TCT in his possession without having transferred it to his name. A few years later, thereafter, when he had already had the funds to pay the transfer costs, Dempsey went to the Registry of Deeds of Dumaguete and discovered that after the sale, Daria had filed a petition for reconstitution of the owner's duplicate copy of TCT number 777, which the RTC granted. Thus, unknown to Dempsey, Daria was able to secure a new TCT in her name. What is Dempsey's remedy to have the reconstituted title in the name of Daria nullified? Suggested answer: Dempsey's remedy to have the reconstituted title in Daria's name nullified is to file with the Court of Appeals a petition for annulment of the RTC judgment. In a case involving similar facts, the Supreme Court held that the RTC has no jurisdiction to issue an order for the issuance of new owner's duplicate title if the owner's duplicate title was not actually lost, but was in the possession of a person who had bought the property. The order of the RTC may be set aside under Rule 47 of the Rules of Court because the order is void for lack of jurisdiction. Bar question number 10. In a buy-bust operation, 30 kilos of shabu were seized from Dave and Daryl. They were arrested and placed on inquest before Prosecutor Danilo, Don, who ordered their continued detention. Thereafter, the information for the sale and distribution of shabu was filed in court. When arraigned, Dave and Daryl pleaded not guilty to the charge. During pretrial, counsel for both of the accused raised for the first time the illegality of the arrest. The case proceeded to the trial. After the trial, the court scheduled the promulgation of judgment with notice to both the accused and their counsel, Attorney Di Mayuga. During the promulgation, only Dave and Attorney Di Mayuga were present. Both the accused were convicted of the crime charge. Question letter A. Was the challenge to the validity of the arrest timely raised? Suggested answer: no, the challenge to the validity of arrest was not timely raised. Under the Rules of Criminal Procedure, Section 9, Rule 117, lack of personal jurisdiction, which includes the ground of an invalid or illegal arrest, must be raised in a motion to quash before plea. Otherwise, such ground is deemed waived. Here, Dave and Daryl raised the illegality of the arrest only during the pre-trial and not before plea. Hence, the challenge to the arrest validity was not timely raised. Question letter B. What is the remedy available to Daryl, if any, to be able to file an appeal? Suggested answer: the remedy for Daryl in order to be able to file an appeal is to file within 15 days from the promulgation a motion for leave of court to avail of the remedy of appeal. Because under the Rules of Criminal Procedure, in a case judgment of conviction and the accused failed to appear, he shall lose the remedies available under the rules, and thus he should surrender and file such motion and prove that his failure to appear was for justifiable cause. Section 6, Rule 120 of Rules of Court. Bar question number 11. In 2007, the Court of Appeals Justice Dred Dong was appointed to the Supreme Court as Associate Justice. Immediately after the appointment was announced, several groups questioned his qualification to the position on the ground that he was not a natural-born citizen. In the same year, the court issued an order enjoining him from accepting the appointment or assuming the position and discharging the functions of his office until he is able to successfully complete all the necessary steps to show that he is a natural-born citizen of the Philippines. However, he continued to exercise his functions as Court of Appeals Justice. Since the qualification of a natural-born citizen applies as well to Court of Appeals Justices, Attorney Dasho, a practicing lawyer, asked the Office of Solicitor General through a verified request to initiate a quo warranto proceeding against J. Dong in the latter's capacity as incumbent Court of Appeals Justice. The OSG refused to initiate the action on the ground that the issue of J. Dong's citizenship was still being litigated in another case. When the OSG refused to initiate a co-warranty proceeding, Attorney Dasho filed a petition for certiorari against the OSG and certiorari and prohibition against J-Dong. The petition for certiorari against OSG alleged that the OSG committed grave abuse of discretion when it deferred the filing of a co-warranty proceeding against J-Dong, while the petition for certiorari and prohibition against J-Dong asked the court to order him to cease and desist from further exercising his powers, duties, and responsibilities as Court of Appeals Justice. In both instances, Attorney Dasho relied on the fact that at the time of J-Dong's appointment as Court of Appeals Justice, his birth certificate indicated that he was a Chinese citizen and his bar records showed that he was a naturalized Filipino citizen. Question letter A. May the OSG be compelled in an action for certiorari to initiate a co-warranty proceeding against J-Dong? Suggested answer: no, the OSG may not be compelled in an action for certiorari to initiate a co-warranty proceeding against J-Dong. In a case involving similar facts, the Supreme Court held that the issue of whether to bring or not a co-warranty proceeding is within the sound discretion of the OSG, which may not be compelled to do so, especially where the issue of citizenship is being litigated in another case. Question letter B. Does Attorney Dasho have the legal personality to initiate the action for certiorari and prohibition against J-Dong? Suggested answer: no, Attorney Dasho does not have the legal personality to initiate the action for certiorari and prohibition against J-Dong. In a case involving similar facts, the Supreme Court held that the action, while denominated as one for certiorari and prohibition, is essentially one for co-warranto, since it seeks to oust J-Dong from the office of Court of Appeals Justice, and that, since Attorney Dasho has shown no right to the office of Court of Justice, he is bereft of legal personality to initiate the action. Bar question number 12. Dudu was knocked unconscious in a fist fight with Dindo. He was rushed to the emergency room of Medical City where he was examined and treated by Dr. Datu. As he was being examined, a plastic sachet appearing to contain a shabu fell from Dudu's jacket, which was on a chair beside him. Dudu was arrested by the same policeman who assisted him to the hospital. At Dudu's trial, the public prosecutor called Dr. Datu to the witness stand. When the public prosecutor asked Dr. Datu as to what he saw in the emergency room, Dudu's counsel objected, claiming doctor-patient privilege rule. How would you rule on the objection? Suggested answer: I would overrule the objection, because under the rules of evidence, the doctor-patient privilege applies only to civil cases and not to criminal cases. Bar question number 13. Denny is on trial for homicide. The prosecution calls Danilo, a police officer who interviewed the victim Drew shortly after the shooting. Danilo's testimony is being offered by the prosecution for the purpose of proving that, number 1, Drew is now dead. Number 2, while in the emergency room, Drew was posting his medical condition on Facebook and was liking the posts of his Facebook friends. Number 3, Drew asked the nurse for water but refused because he was bleeding, which subsequently angered Drew. And number 4, that before dying, Drew signed a statement in which he identified Denny as the shooter. Is the proposed testimony of Danilo admissible? Suggested answer to number 1. Danilo's testimony is admissible for the purpose of proving Drew's death. Under the law on evidence, the hearsay rule does not apply to facts which are undisputed. Here, there is no showing that the fact of Drew's death was disputed. Hence, Danilo's testimony is admissible. Suggested answer number 2. Danilo's testimony is admissible for the purpose of proving that Drew was posting his medical condition on Facebook and was liking the posts of his Facebook friends. Under the law on evidence, an independent relevant statement is not covered by an hearsay rule and is admissible in evidence. Here, Danilo's testimony relates to Drew's belief or state of mind on his medical condition and on his emotion or feeling. Hence, it is independently relevant. Suggested answer number 3. Danilo's testimony is admissible for the purpose of proving that Drew asked the nurse for water and was angered when refused by the nurse. Here again, the testimony related to Drew's state of mind or emotion. That is, he was angry and is hence an independent relevant evidence which is admissible. Suggested answer number 4. Danilo's testimony is inadmissible for the purpose of proving that he identified Denny as the shooter. Under the rules on evidence, a dying declaration in order to be admissible as an exception to the hearsay rule must be made under the consciousness of impending death. Here, there was no showing that Drew was conscious of his impending death. In fact, he was posting on Facebook and liking the posts of his Facebook friends, which are not the actions of one who is about to face his maker or about to die. Hence, the statement that it was Denny who shot Drew is inadmissible for being a hearsay. Power question number 14. Dave is on trial for sexual assault of Delhi, a law student who sidelines as a call center agent. Dave offers the testimony of Danny, who says that Dave is known in the community as decent and discerning person. The prosecution presents a rebuttal witness, Dovey, who testified that if Dave was reputed to be a good person, the reputation was a misperception because Dave had been previously convicted of homicide. Is Dovey's testimony admissible as to the character of Dave? Suggested answer: no, Dovey's testimony is not admissible as to the character of Dave. Because under the law on evidence, where character is used as circumstantial evidence, the evidence to prove such character is limited to reputation evidence. Here, character was introduced by Dave as circumstantial evidence. That is, the crime charge is inconsistent with a decent and discerning character. Hence, the prosecution's rebuttal evidence, which was based not on reputation but on a past conviction, is inadmissible. Moreover, evidence on the prior conviction would run afoul of the similar acts rule. Bar question number 15. Attorney Dalmasio, the director of the National Bureau of Investigation, applied for a search warrant before the executive judge of RTC Manila. He alleged in his application that a certain alias Django was keeping about 10 kilos of shabu in a wooden cabinet located at Dilian's store in Paseo de Santa Rosa, Laguna. The executive judge of Manila personally examined Attorney Dalmasio and his witnesses and thereafter issued the search warrant, particularly describing the place to be searched and the items to be seized. Question letter A. Can the search warrant issued by the executive judge of Manila be enforced in Laguna? Suggested answer to letter A. Yes. The search warrant issued by the executive judge of Manila can be enforced in Laguna. Under Supreme Court issuances, application for search warrants involving dangerous drugs may be filed with executive judge of the RTCs of Manila by the NBI. The search warrant is enforceable outside territorial jurisdiction of Manila. The application shall be personally endorsed by the head of the NBI. Question letter B. Can the legal concept of venue is jurisdictional be validly raised in application for search warrants? Suggested answer to letter B. No, the legal concept of venue is jurisdictional, cannot be validly raised in application for search warrants. The Supreme Court has held that an application for search warrant is not a criminal action but a special criminal process. Hence, the place where the application is to be filed is governed by Supreme Court rules and issuances, and not by the criminal procedure concept of venue is jurisdictional, which applies only to criminal actions. Bar question number 16. Danjo, a stay-in gardener at the D family home in Quezon City, applied for overseas employment in Riyadh as a flower arranger. After he left for abroad, Dino D, head of the family, discovered that all his wristwatches were missing. Dino followed Danjo's Instagram account and in one instance saw Danjo wearing his Rolex watch. He filed a complaint for qualified theft against Danjo with the Office of the Prosecutor, Quezon City. The subpoena with the affidavit complaint was served on Denden, Danjo's wife, at their house. No counter affidavit was filed by Danjo, who continued to work in Riyadh. After conducting a preliminary investigation, the Office of the Prosecutor found probable cause against Danjo and subsequently filed the information for qualified theft before the RTC of Quezon City. The court likewise found probable cause and issued on 2016 a warrant for Danjo's arrest. Danjo was repatriated to the Philippines in 2018. While Danjo was lurking outside this house, which was only about 100 meters away from the police station, SPO1 Dodi recognized Danjo. Realizing that the police station had a copy of Danjo's warrant of arrest, SPO1 Dodi immediately pursued and arrested Danjo. Question letter A. Was the warrant of arrest issued against Danjo, who was not in the Philippines, valid? Suggested answer to letter A. Yes, the warrant of arrest issued against Danjo, who was not in the Philippines, is valid. Under the rules of criminal procedure, the investigating prosecutor may resolve the complaint based on the evidence before him, even if a respondent could not be subpoena. As long as efforts to reach a respondent were made and he was given an opportunity to present countervailing evidence, the preliminary investigation remains valid. Question letter B. Can the warrant of arrest be served on Danjo upon his return? Suggested answer to letter B. Yes, the arrest warrant can be served on Danjo upon his return. Under the law on criminal procedure, an arrest warrant is valid until served. Bar question number 17. Don Deles, a contractor, was sued together with Mayor Dante Dungo and Congressman Dal Dilim for malversation of public funds before the Office of the Ombudsman. Danny Dean, a material witness of the complainant, Diego Domingo, was hired as an engineer by a construction company in Qatar and had to depart in 2 months. To perpetuate Danny Dean's testimony, Diego Domingo applied for his conditional examination before the Sandigan Bayan. Should the application for conditional examination of Danny D be granted? Suggested answer: no, the application for conditional examination of Danny D should not be granted, because under the rules of criminal procedure, the conditional examination of a prosecution witness can be made only before the court where the case was pending. Section 15, Rule 119 of Rules of Court. Here, there was no showing that a criminal case had already been filed by the Ombudsman with the Sandigan Bayan. Moreover, the prosecution of a criminal cases shall be under the direction and control of the public prosecutor, which in this case is the Office of the Special Prosecutor. Diego Domingo, who is merely the private complainant, has no legal personality to apply for conditional examination of a prosecution witness. Bar question number 18. The Republic of the Philippines, or Republic, filed a complaint with the Sandigan Bayan in connection with the sequestered assets and properties of DIMO Companies Incorporated, or DIMO, and impleaded its officers and directors. Since the complaint did not include Dimo as defendant, the Sandigan Bayan issued a resolution where it ordered Dimo to be impleaded. Thereafter, Republic filed an amended complaint naming Dimo as additional defendant, which amended was later admitted. Dimo filed a motion for a bill of particulars for the Republic to clarify certain matters in its amended complaint. The Sandigan Bayan immediately granted the motion. Upon submission of the bill of particulars by the Republic, Dimo filed a motion to dismiss, arguing that the answers in the bill of particulars were indefinite and deficient responses to the question of what the alleged illegally acquired funds or properties of Dimo were. The Sandigan Bayan dismissed the case. Question letter A. Was the Sandigan Bayan correct in dismissing the case? Suggested answer to letter A. Yes, the Sandigan Bayan was correct in dismissing the case because in a case involving similar facts, the Supreme Court held that the dismissal of a case for failing to file a proper bill of particulars is a ground for dismissal of the case for failure to comply with the rules or with an order of the court. Question letter B. What can the defendant in a civil case do in the event that his motion for a bill of particulars is denied? Suggested answer to letter B. In the event that his motion for a bill of particulars is denied, the defendant in a civil case can file his answer within the remaining period, which is no case shall be less than 5 days. Section 5, Rule 12 of Rules of Court. Bar question number 19. Darrell Vick, a German national, married Dara, a Filipina, in Dusseldorf, Germany. When the marriage collapsed, Dara filed a petition for declaration of nullity of marriage before the RTC of Manila. Darrell Vick, on the other hand, was able to obtain a divorce decree from German family court. The decree in essence states that the marriage of the parties contracted before the civil registrar of Dusseldorf is hereby dissolved. The parental custody of the children Dector and Dawas is granted to the father. Darrell Vick filed a motion to dismiss in the RTC of Manila on the ground that the court no longer have jurisdiction over the matter as a decree of divorce had already been promulgated dissolving his marriage to Dara. Dara objected, saying that while she was not challenging the divorce decree, the case in the RTC still had to proceed for the purpose of determining the issue of the children's custody. Darrell Vick counters that the issue had been disposed of in the divorce decree, thus constituting res judicata. Letter A. Should Darrell Vick's motion to dismiss be granted? Suggested answer to question letter A. No, Darrell Vick's motion to dismiss should not be granted. In a case involving similar facts, the Supreme Court held that the foreign divorce decree did not constitute res judicata as to the issue of parental custody, since there was nothing in the decree as to who between the parents was at fault, and thus the RTC could still determine the issue of parental custody. Question letter B. Is a foreign divorce decree between a foreign spouse and a Filipino spouse, uncontested by both parties, sufficient by itself to cancel the entry in the civil registry pertaining to the spouse's marriage? Suggested answer to letter B. No, the foreign divorce decree between a foreign spouse and a Filipino spouse is not by itself sufficient to cancel the entry in the civil registry pertaining to the spouse's marriage. The Supreme Court has held that before a foreign divorce decree dissolving a marriage contracted in the Philippines can be given effect, a petition for judicial recognition of the foreign divorce decree should be first filed. Bar question number 20. Dominic was appointed Special Administrator of the State of Dakota Dragon. Delton, husband of Dakota, together with their 5 children, opposed the appointment of Dominic, claiming that he, Dominic, was just a stepbrother of Dakota. After giving Dominic the chance to comment, the court issued an order affirming the appointment of Dominic. Question letter A. What is the remedy available to the oppositors? Suggested answer to letter A. The remedy available to the oppositors is to file a motion for reconsideration, and if denied, to file a special civil action for certiorari under Rule 65. Under the Rules on Special Proceedings, the order appointing a special administrator is non-appealable. The Supreme Court has held, however, that such order can be challenged by a special civil action for certiorari if it can be shown that the appointment was made with grave abuse of discretion. Question letter B. If there are no qualified heirs, can the government initiate escheat proceedings over the assets of the deceased? To whom in particular shall the estate of deceased go, and for whose benefit? Suggested answer to letter B. Yes, the government can initiate escheat proceedings over the assets of the deceased pursuant to the rule on escheat, Section 1 of Rule 91 of Rules of Court. In particular, the estate of deceased shall go to and be for the benefit of the following. The personal estate shall go to the municipality or city where deceased last resided in the Philippines, and the real estate shall go to the municipality or city in which the same is situated. If the deceased never resided in the Philippines, the whole estate shall go to the municipality or city where the same is located. Such estate shall be for the benefit of public schools, public charitable institutions, and centers in said municipalities or cities. Section 3 of Rule 91 of Rules of Court. Question number 21. The municipality of Danao, Cebu was a quiet and peaceful town until a group of miners from Denmark visited the area and discovered that it was rich in nickel. In partnership with the municipal mayor, the Danish miners had to flatten 10 hectares of forest land by cutting all the trees before starting their mining operations. The local DNR, together with the Samahan Laban sa Sumisira sa Kalikasan, filed a petition for writ of kalikasan against municipal mayor and the Danish miners in the RTC of Cebu. Question letter A. Is the petition within the jurisdiction of RTC Cebu? Suggested answer to letter A. No, the petition for writ of kalikasan is not within the jurisdiction of the RTC of Cebu. Under the Rules of Procedure for Environmental Cases, a requisite for availing of the writ of kalikasan is that there must be an allegation that the environmental damage is of such magnitude as to prejudice the life, health, or property of inhabitants in 2 or more cities or provinces. Here, there was no such allegation or showing. Moreover, the petition for writ of kalikasan is within the jurisdiction of Court of Appeals, not the RTC. Question letter B. What is the precautionary principle? Suggested answer. The precautionary principle is the principle which states that when human activities may lead to threats of serious and irreversible damage to the environment that is scientifically plausible but uncertain, the court shall take actions to avoid or diminish that threat, notwithstanding that there is a lack of full scientific certainty in establishing a causal link between the human activity and the environmental effect. Bar question number 22. Danica obtained a personal loan of 180,000 pesos from Dingoy, payable in 18 equal monthly installments of 10,000 pesos until fully paid. In order to complete her payment at an earlier date, Danica instead paid 20,000 pesos monthly and continued doing so until the 18th month, which payments Dingoy all accepted. Later on, she realized that she had overpaid Dingoy by 100%, as she should have already completed payment in 9 months. She demanded the return of the excess payment, but Ningoy completely ignored her. Thus, Danica availed of the rules of procedure for small claims cases by filing before the municipal trial court a statement of claim, together with the required documents. Should the MTC proceed with the case under the number 1. Revised Rules on Summary Procedure? Suggested answer to number 1. The MTC should not proceed with the case under the Revised Rules on Summary Procedure because under the said rules, cases where the amount of the claim in municipal trial court exceeds 100,000 are not covered by it. Number 2, should the MTC proceed with the case under the Rules of Procedure for Small Claims? Suggested answer to number 2, the MTC should not proceed with the case under the Rules of Procedure for Small Cases because under the said rules, a demand or claim for money which does not arise from contract are not covered by it. Damages arising from quasi-contract were deleted from the coverage of the said rules. Here, the claim or demand does not arise from contract, but from a quasi-contract of solutio indebiti, the overpayment having been made by mistake. Question number 3. Should the MTC proceed with the case under the regular procedure for civil cases? Suggested answer to number 3. Yes, the MTC should proceed with the case under the regular procedure for civil cases since it is not covered by the 2 preceding rules. Thank you for watching. Please like and subscribe to my channel. Have a blessed day. Goodbye.